and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm Matthew Bruckner, Associate Professor of Law at Howard University School of Law. My guest today is Anthony Michael Kreis, Visiting Assistant Professor of Law at Chicago-Kent College of Law, where he is also an affiliated faculty with the Chicago-Kent Institute for Law and the Workplace. Welcome back to Ipsa Dixit.
Well, thanks for having me.
Thanks for joining. So I was really excited that you were going to be my first interview subject. We met some time ago at, I think it was the Richmond Junior Faculty Forum, and been sort of following your stuff, even though it's a little bit outside of what I usually work on. But so I just wanted to talk with you about your article, Defensive Glass Ceilings, which is, I understand, forthcoming in the George Washington Law Review.
It is, yes.
All right. So can you talk to me a little bit about the article, maybe, how this one fits with your larger research agenda, why this particular topic?
Yeah. So a lot of my research recently has been on Title VII issues, in particular, about issues of sex and sexuality and gender in the workplace, and it fits. This particular piece was something that came out of some of the responses I saw from the corporate sphere to Me Too. And a part of my broader research agenda beyond just employment law or employment discrimination is the idea, to study law and social movements. So this piece, in a lot of ways, is the marriage of both my very, my 40,000 foot level academic agenda, and it's the confluence of a number of different areas of interest to me in the employment context. So that's kind of where I'm coming from. The initial motivation for the article, though, I guess it was maybe a year and a half ago now, maybe almost 2 years ago, when news reporters began to talk about Mike Pence and the vice president's so-called Pence rule. Which was the vice president's rule when he was a member of Congress, that he wouldn't socialize with women who were his employees. He wouldn't let female staffers work late with him. And so there were a whole lot of restrictions that he placed on women in his congressional office. And that struck me as being just viscerally wrong, as a kind of a moral perspective. But of course, I also had Title VII concerns, and this was at the same time that I had been kind of just thinking about this earlier case from the Iowa Supreme Court, which dealt with the spousal jealousy, and there was another case in New York that was percolating in the New York state court system that had to deal with some form of spousal jealousy and attractiveness in the workplace. And so all these kinds of all these cases, and then the Me Too movement, right? Everything just kind of lined up in a perfect storm for me, at least, where I thought, well, there's something bigger here, right? There's an article to be written about how these seemingly disparate pieces of litigation and the social movement, how it all fits together. So that's why I decided to write the article.
Right. No, I agree. This was a really interesting topic. I remember the sort of hue and cry about the Pence rule, or the Pence-Graham rule, because you sort of attach it to not just Mike Pence, but right. So, I thought that the article sort of did a good job sort of pulling together these different strands that you sort of talk about. But could you sort of maybe just take a moment to sort of summarize like the thesis that emerges from this article when you pulled it all together?
Yeah. So there's three different types of discriminatory workplace practices that I looked at. And the bottom line is whether it's attractiveness, whether it's kind of an associational based form of discrimination, or whether it's a workplace rule of engagement like the Pence rule, that any kind of workplace practice that segregates women out and essentially marks women for second-class status in this way should be deemed an unlawful practice, right? That we should see these things as not disparate kinds of workplace practices, but we should see it as a systemic form of gender policing and gender discrimination. And ultimately, the reason why they are unlawful is because they are a structural form of discrimination that women in particular, because women use social networking like men to advance in their careers, that when people police women and try to keep them away for whatever reason, whether it be some kind of individual concern about liability, or whether it be spousal jealousy, or whether it be because a man thinks he can't have an attractive female in his office, that all these things prevent women from enjoying a positive career trajectory, and the law needs to step in and call all of these things sex discrimination and permit employees who are discriminated against with these kinds of practices to pursue lawsuits.
Great. So I'm curious because you do certainly, I think, center the article on women, and even, I mean, certainly the title "Defensive Glass Ceiling" sort of evokes the idea of sort of women sort of not being able to sort of achieve the upper reaches of management, and now you're positing that it's because men are sort of not letting them sort of network and whatnot for a variety of reasons. You do at some point talk about sort of work-spouse relationships and suggest that work-spousal relationships are not just sort of between the genders, but are sometimes sort of male-male or female-female. And it struck me, and please correct me if I'm wrong, that at time you're talking about sort of that management's concern about these sort of platonic workplace relationships sometimes drove some of these sort of defensive glass ceilings that you're talking about. But in some of these cases, it struck me that it was but this sort of issue potentially related to discrimination against men as well. So is the concern you have purely about women, or is that just is that sort of the sort of, I don't know, the motivating force, but it does have broader applicability?
Yeah, so it certainly has broader applicability, right? So if, for example, a man discriminates against another man because he's in a same-sex marriage, and his spouse is jealous, and that causes some kind of adverse employment action, that of course should be actionable under Title VII. So there's a case from 1998 called On Cal, where the Supreme Court essentially held that same-sex harassment is actionable because it is still because of sex, right? So the same principle applies here. The reason why I often frame it as an issue of women being, women's careers being depressed as a result of these kinds of defensive employment practices, is because more often than not, they're only permitted, or they can only happen in environments where the labor market or the workplace environment is male dominated already. Mm-hmm. And so that's why that dynamic often happens. There's also an issue here of kind of a compulsory heterosexuality, which I think is also interesting, particularly in the Pence rules, right? So the idea that, if a man says, well, I won't engage with women socially or, late night hours, or I won't travel with a woman alone for work, right? There's this idea that, right, that the man has that the woman must have some potential to be sexually attracted to him, right? So there's that dynamic, which is also interesting. But again, a lot of these things, the reason why they're phrased the way they are is because that's how the power dynamics tend to play out. But again, when a same-sex dynamic is present, that's not prohibitive of plaintiffs who are discriminated against because of their sex to bring those claims forward.
Yeah, certainly. That's how I understood the article. But as you say, the way it's sort of couched, and especially the title sort of evokes the sort of idea of sort of men sort of keeping women out of potential interactions. But that certainly makes a lot of sense.
Right. And the interesting thing here too, right, is a lot of this goes back to the mid 1970s modern feminist literature on employment discrimination and sexual harassment. And one of the things that I find so interesting and telling from that literature, which applies here, is that particularly where the numbers of women in a particular workplace are small, right? So you don't have a huge number of women in that particular workplace environment. Those are the kinds of environments where sex stereotypes are much more likely to be used against women, where these kinds of tokenism, stereotypes will be particularly acutely felt by female employees. And we see that, at least anecdotally, in some of the environments that these defensive glass ceilings are being are being erected, right? So a lot of, it's law firms and Wall Street and political offices. So it's really interesting that the kinds of structural barriers that women writing in the mid 1970s and 1980s were concerned about are manifesting in those exact same kinds of environments that they warned that they would manifest, right, even now in 2018, 2019.
And so, why do you think that is? I think law firms, in particular, I mean, I'm maybe just more familiar with them, have been at least ostensibly trying to make the workplace more welcoming to women, to have women sort of stay on, to promote them, but you're suggesting that they are amongst the sort of most challenging environments in terms of sort of these defensive glass ceilings and sort of the lack of sort of mentoring opportunities. So, do you have any thoughts as to why these particular workplaces are sort of suffer the most from what you're talking about?
Yeah. So there's two interesting issues here, right? One, you have a question of recruiting and getting women in the door in the first place, and then there's the issue of retention. And I think that a lot of these companies have done a much better job recruiting women, recruiting diverse candidates to come and work for them. Where they have maybe been less successful is keeping them there. And, particularly law firms and Wall Street, these are very high stressful environments, and it's hard to keep right? It's hard to keep a lot of their employees, and their talent is probably easily lost. My suspicion is that they just have not done as good of a job, as a general matter, trying to keep women and other diverse candidates there. Part of the issue, I suspect, and this is again something that I'm not exactly sure of, but my gut says that it's really hard when there's these kind of old boys clubs that still run the show,
sure,
to try to pull yourself through the ranks and really get work your way up that ladder, when those opportunities, which many of which are social, are kept away from women and LGBT people too. And so, if you don't see your career going somewhere, right, you may choose to leave and find somewhere else where you're more valued. So I think that's really a lot of what's going on here. It's organizational culture, it's organizational structure. And, these businesses and companies and firms just simply need to do a better job of recognizing that it's not about just recruiting, getting people in the door, but it's about keeping them there, making them feel welcomed, and really appreciating the value and talent that all their employees bring.
I think that's an interesting point. I'm a believer that as soon as you realize you don't want to be your boss, that it's time to leave and to try to find a job where you might want to sort of move up. And I think what you're suggesting is that women sort of perhaps don't see themselves taking on these roles, in part because there are no or are very few women in the sort of upper management. And to the extent that there have been inroads in sort of recruiting, it may be that this sort of, old boys network, as you're suggesting, is sort of giving a fig leaf to diversity, whether it's sort of gender or racial or sexual orientation or otherwise, but they're not investing the resources in retention. But again, I find that interesting too, because, my sort of understanding is that it is expensive to recruit and bring on board, say, new lawyers, and if they don't stay for a while, then that's not clearly a good investment in the recruiting phase, at least. And so, but perhaps that's just because they're sort of making overtures to recruit, but they're not really committed to a more diverse workplace.
Yeah, I think that's so important, right? And again, some companies and firms and like have done a good job, at least, of being on, right, to at least at some superficial level, concerned about issues of diversity and inclusion. But of course, we've seen the data where, a large percentage of women have, said that they've been sexually harassed, for example, in the workplace. So that suggests to me that there's still something deeply, right, and culturally problematic about these organizations. And until those issues are fundamentally addressed beyond, right, some of the kind of niceties, for example, a lot of firms will have things for Pride and they'll promote LGBT issues, but if LGBT employees are not comfortable every day, then those events in the month of June are somewhat meaningless to those employees, right? It's a nice gesture, but it doesn't make up for the fact that they may not feel safe or comfortable or appreciated at work on a day-to-day basis. So yeah, I think that's addressing these issues, the root issues, in a very fundamental way is important.
All right, so you're sort of emphasizing that there's a problem, but of course your article is also about how to address this problem. So can you talk a little bit about the various aspects of Title VII that have been used before, and the sort of where they haven't been successful, and your suggestion about how to bring about sort of change and to eliminate these defensive glass ceilings?
Yeah. So I think there's a couple of issues. The first one, if we just tackle the Pence rule for a second. Now, the Pence rule is interesting. That I often refer to it as that because that's what people talk about it now. But for decades before, people talked about it as the Graham rule, right? Which was a reference to Reverend Graham having a similar rule for himself. And that dates back to the 50s and 60s. What's important here, and what I think that illustrates, is that some of these issues are not new. And I think it's a mistake for us to assume that some of the reactions in the modern workplace and some of the things that we're seeing men in particular do in the workplace in response to, for example, Me Too, aren't new. And in fact, are just a doubling down of pre-existing practices that have been around for a long, long time. And I think that's important because we really need to call this out for what it is. And it's a form of, in my view, it's a form of sex segregation. And as long as we talk about it in terms of being a form of sex segregation, I think that puts in a better understanding that this is the same kind of problem women saw in the 1970s and 1980s. We're just seeing it now in a different kind of light, in a different context. Now, the issue is in Title VII twofold. Title VII, courts have interpreted one provision of Title VII as requiring an adverse employment action, which means that in order for an employee to bring a actionable discrimination claim under Title VII, they have to suffer something of real material consequence. Now, it's easy if they've been fired or been docked pay, right? That's an easy case. What becomes less easy is when courts perceive basically employees or former employees as being aggrieved over petty trivialities, right? So their office was moved, or they were, they weren't invited to a birthday party, right? Things like that. And the idea that there is that Title VII is not a all-round, all-purpose civility code. Now, I think that if women can show that a Pence-Graham rule is in place and that they are being denied the opportunity to engage in workplace activities, social functions, and are kept away from opportunities in the workplace because they are women, that's an easy, right? That should be, in my view, an easy showing that there's an adverse employment action made against them, and that they have a Title VII claim as a result. So I do make or put forward in the article that traditional understanding of adverse employment action should allow, in this context, a plaintiff to go forward.
And do you, in this context, separate out women being excluded from sort of late night working events with their male boss versus not being invited over to play poker?
So that's what's interesting, right? I think that could be a piece of evidence that there's a broader, more systemic problem in the workplace, and that there is some form of sex segregation happening. Now, that's where, and again, I think that's where we get into a very tricky gray area, right? What kinds of actions are just petty slights? What are just people exercising personal their personal preferences for who they associate with, and what's a real tangible employment loss, an opportunity loss. I think, again, it could be a piece of evidence in a grander, showing. But what troubles me or concerns me in particular is that women might have these claims and might show in a traditional Mike Pence setting that this kind of Pence or Graham rule has been or put in place. But the courts might not see it as being that serious of a concern. And that's what concerns me here. And so I offer an alternative route for plaintiffs to bring a claim, which doesn't rely on that adverse employment action doctrine as much as the traditional claims are brought forward. And so what I suggest here is that we look at this as being employment practices which tend to deny women an opportunity for advancement, and tends to deny women equal opportunity in the workplace. And there's a section in Title VII which is often underused, which says that is in fact an unlawful practice in its own right. And so that's what I'm arguing for in the paper here, that we should see these that women who feel as if they are being mistreated and are subjected to these kinds of rules of engagement, or as I call them, sex quarantines, that they should be permitted to pursue claims under both theories, both parts of the statute. And in doing so, I hope that judges will have the cultural competency to understand the real impact of what's happening here, and why it is an unlawful practice, and why it's a form of sex segregation, not new in the wake of Me Too, but in fact the same thing that we've seen in decades past.
Mm-hmm. Yeah, so I found this interesting, this idea that I think was Section 703A2, and as you know, and but for the listeners, I'm not a sort of a Title VII expert by any means. So you describe it as sort of being sort of little used, and I'm curious about that. So you suggest this as an alternative route, but is it just been a missed opportunity? Why haven't plaintiffs' lawyers been bringing these claims, or why haven't they been successful so far? You've identified this as a possible route, but I'm just curious about why it's not a sort of a well-trodden route.
Yeah. So initially, when when people thought about this section of Title VII, a lot of, or generally, it was associated with disparate impact claims. Sorry, and when Congress revamped the Title VII in 1991, they created an entire section dedicated to disparate impact claims, and then they left this section on its own, which suggests to me that there is something more meaningful to this section than just disparate impact claims, right? So that there's something here that Title VII provides, which is beyond disparate impact, and so one of the things that there have been a number of cases that have brought this that have cited this section before, but a lot of them were successful in the 70s when segregation was very easily made out, right? So that there were jobs that were for women and there were jobs that were set aside for men. And so you could use this section to say, well, you, the employer, are segregating based on sex and that tends to deny us opportunities. And it was a much more clearer case to make, as those kinds of very obvious forms of segregation have receded from the workplace. I think that maybe it's just not been thought of as viable of an option. There have been plaintiffs who have brought these claims, in recent times. Last year, there was a case at the Seventh Circuit, in fact, that that brought it was the EEOC brought it against AutoZone, where a man was transferred from one store to another based on the racial dynamics of the customers at those stores and the race of the employee. Now, it's probably too complicated to get in that particular case too much for our purposes, because I think that might be a case where bad facts made some bad law. But it does illustrate that there are people who are thinking about this alternative provision. The EEOC is willing to bring claims under it, and these are not These are not disparate impact claims. They are individuals who are being treated in an intentionally discriminatory fashion. So I do think that there's a lot of there is some prospect here that this could be reinvigorated for these for women who feel discriminated against because there's some kind of sex quarantine in place in the vein of a Mike Pence Reverend Graham rule.
Mm-hmm. I thought that was a really interesting case that you talked about. I agree. We shouldn't get into the weeds on it, but it reminded me of there was a Freakonomics podcast not too long ago about ethnic restaurants and how Japanese restaurants often have folks who are, generally of sort of Asian appearance, although very often not Japanese. And, Mexican restaurants often have Hispanics, although certainly not just Mexicans. And it seems like there's lots of environments where that sort of this case that you were discussing really had maybe sort of broader applicability in terms of potential employment discrimination.
Yeah, and what's the thing that so many of the members of the public maybe don't necessarily understand is the intention behind discriminatory acts is irrelevant, right? So you can have a benevolent motive, but that still doesn't make it any less unlawful. And so you can't take for the most part a customer's preference into consideration and then make a racially discriminatory or sex-based discrimination employment decision just because your customers want that. And in a similar sense, part of the discriminatory practices that I'm discussing in this paper, they often are couched by the discriminating parties, right, the employer or the supervisor, as being right, this kind of chivalry, some form of chivalry, or it is, it's a form of, it's an honorable, benevolent position to take, that they're protecting women from would-be harassers, or they're protecting their family, or they're protecting their own reputation. And those justifications aren't right. They aren't any better than someone who just says, I don't want to hire women, right? It still has the same effect of denying women equal employment opportunities. And that, right. So that's important, I think, to understand here, that the justifications can be, paint or couched in as rosy of a picture as employers and supervisors and like want, but it doesn't matter.
So I think that was a really interesting point too, because I do agree that it seems to be couched this way, that we need to protect women from, but from what? I mean, I think the argument is really like we're protecting women from their sort of undeniable attraction to these very powerful male figures, right? Like it's. I think you said this earlier, that it's suggesting that these women, but for the protection of being excluded from workplace events or sort of late nights with their male bosses, would, I'm not sure what, sort of throw themselves at their male bosses. And so it seems like they are not just sort of excluding women, but are sort of, in some sense, glorifying their own sort of attractiveness to their female employees.
Yeah. So the one point I try to make in the paper, and I think I've done a better job in a future draft, is to talk about the animating ideology that seems to have perhaps come into greater clarity in the post-Me Too era. And that is this idea of ambivalent sexism. We often think about sexism as either being purely hostile or purely benevolent, right? So hostile sexism being, we don't want women here, women don't belong in this kind of job, so therefore we won't hire women. Benevolent sexism being more along the lines of, we must protect women as men, and we must have, it's kind of, it's more condescending in nature, right? And paternalistic. And this form, the discriminatory practices that eventually erect these defensive glass ceilings are really at dead center at the intersection of hostile and benevolent sexism, because what they're saying is right, we have all these negative stereotypes about women. Women are, they're temptresses, and women will make false reports against men, and right, women are irresistible, and they will use their sexuality to get ahead at the expense of men. At the same time, the justifications for keeping women away aren't really couched in those hostile those hostile stereotypes, but it's more along the lines of, well, we are doing this to protect our own reputation and to keep our wives happy and safe, and to keep women safe from harassers, right? So they're trying to have their cake and eat it too, in a sense, right? Where they're doing something that is outright hostile, and they're using benevolent justifications, right, to kind of paper over or at least what they think is to attempt to paper over those stereotypes which are animating this hostile work environment. So I think it's really quite interesting to see how that dynamic has played out, particularly again in the wake of the Me Too movement. It seems that the fear that men have, which are motivated by the hostile forms of sexism, have led to a much more openness using these benevolent justifications, which I'm just almost shocked at how open some people have been in professing why these kinds of practices are either okay and acceptable, or even just outright laudable and should be widely adopted.
Right. Well, I mean, one possibility is that they're not getting penalized for doing so, and so they're like, they believe their own message. The thing that you were saying, this gets into one of my my last questions, because I know Brian likes to keep these around 40 minutes long. is the point that you raise, which is that that it is not okay to discriminate against somebody because of a fear that that your spouse has, that they will sort of tempt you at these sort of late night meetings, or sort of that if you're out late at a work dinner or far away and having a drink, that something will happen. But you do make very clear that it is okay to discriminate against somebody that you that is or was a former lover. And I find that really interesting, that discrimination against someone that you, for example, have had sex with is okay, but someone that you want to, or that you think might want to have sex with you, that is not okay. So can you talk a little bit more about why this distinction? Why would it be okay to discriminate against somebody where there has been, whether they were, say, a former lover, for example?
Yeah. So I'll say from the start, I would categorize those kinds of employment practices as not cool but lawful, and because a lot of times some of the they're just jilted lovers who are taking out their lovers' quarrel in the workplace, right? And oftentimes firing or demoting or really harming a former lover in the workplace in a way that's not really laudable, right? It's not something we want to raise up. But there's a couple of differences between that and some of these other things that employers are doing, which I have deemed unlawful. The first is, are these things because of sex, right? Is it solely because of the individual sex? And I think the answer is no, right? That the reason for the motivation is not because it's just a woman doing and being penalized for something a man, otherwise would not get penalized for. It's because she or he, depending on the situation, entered a relationship that went bad, and right, there's negative consequences to that. So that's one fundamental aspect of it. The second thing is they're different in the sense that they're not imposing generally a structural barrier to progress to equal opportunity for women. Now there is sometimes, and this is tangentially related, if, for example, there's an expectation that all women in the workplace have a sexual relationship with a supervisor in order to maintain their job or to get ahead, right? And it's not quid pro quo, but it's kind of an understood that you need to do this in order to be successful here. Now that should be actionable, because that's different, right? It's not really wanted in the same sense. And it's not structural, or it is structural in the sense that you can't get ahead in that company unless you do it. But I think that's the big difference, right? These other situations are kind of one-offs where it's just a relationship gone bad. It's not because of sex. It's not defensive in the same way that these other things are defensive. It's because someone's feelings were hurt. And as much as we should discourage that kind of retribution being taken out on former lovers and people that we have intimate relationships in the workplace, and there's, I think, whole conversations that can be had about whether there should be rules against that in the first place. They're just of a fundamentally different character than the kinds of things we're talking about here. But I think it's important in the paper to discuss them because when you are talking about particularly, the idea of spousal jealousy, it gets confused or complicated, right? That people kind of mix up, spouses who are jealous, but for no particular reason, right? They can't articulate why they're jealous. They just don't like the presence of a man or a woman in the workplace engaging in the kinds of associations that they're engaging with, versus someone who's actually crossed the line and entered a sexual relationship that was, both voluntary and wanted by them. And so I take care to cabin that off and say that's a different issue, and here is why.
Great. Well, thanks. That's helpful. So look, we are about out of time, but one of the reasons I wanted to interview you in particular, even though this is outside my area, is that I know that you are going to be going on the market again this summer and into the fall. And so, curious if you would just spend a minute to talk a little bit about, your what you're hoping to, where you're hoping to be, what you're hoping to do, take a minute to sort of pitch yourself.
Yeah. So, I guess I always get asked the geography question. I'm happy to go anywhere. I lived everywhere for the last few years, been in Chicago, lived in the South, lived in the Northeast, and, looking forward to starting somewhere new and having a new adventure. So that's that. But I think, the one thing I love about my time here in Chicago, Kent in particular, is I love teaching employment discrimination, and that's certainly something that I hope to do wherever I go next. But I think the one thing that someone can't get necessarily off my FAR form or off my CV or maybe even off my Twitter, although my Twitter might be a little bit more revealing in this, is that I really do value a sense of community. I love my scholarship, particularly when I've done archival research with the PhD background, especially. I just thrive in that environment, and my research and my writing gives me so much satisfaction. But the thing that I get even more satisfaction of beyond my scholarship is just teaching and being in the classroom and forging really a nice rapport with my students and getting to know them and invest in them and invest in the law schools that I've been at and in the communities I'm in. And I think that one thing I hope I'm leaving Chicago Kent with is that or one thing I hope that I can do or say that I've done as I leave Kent and go on to my tenure track position is that I've left Kent a better place, and that my students were better off for having me, and that faculty members their research was better for my being present, and that the community at large was a more enjoyable, thoughtful, and productive place for my being there. And I hope that's what I bring to wherever I go. Because the teaching responsibilities will be what they will, and the research agenda, is going to continue to be law and social change, and oftentimes talking about LGBT rights and other issues. But the one thing that will be fundamentally me and never change is my thirst to really be part of a community and to contribute to it in a really robust way.
Thanks. That's great. I mean, I feel like so often people, when you're on the market, talk about your scholarship as if it's the only thing that matters, and something I certainly really value at Howard. I've enjoyed getting the chance to talk with you today about defensive glass ceilings, but also more generally, and look forward to perhaps seeing you at the annual Chicagoland conference coming up. But again, one way or another soon. So thanks so much for joining me today. And I'll look forward to seeing you again soon.
All right. Well, thanks for having me, and I've enjoyed it.
Wonderful.
Lucky Strike was the first company to advertise for women customers. Their posters showed attractive women, and the slogan reached for a cigarette, not for a sweet. Their sales skyrocketed by 215%, and they became the nation's best-selling cigarette in just 2 years. Women eventually had their own brand of cigarettes called Virginia Slims, with their slogan, "You've come a long way, baby." As a matter of fact, the last commercial for cigarettes shown on television before cigarette advertisements were banned was a Virginia Slims commercial that was shown on The Tonight Show.
You've come a long way, baby.
Virginia Slims. This is the taste for today's woman, with rich Virginia flavor you'll like. Tailored slim for your hands, for your lips. Virginia Slims.
You got Virginia Slims now.